The second, procedural requirements like is the postnatal publicity. And that postnatal publicity, as in case of England, we found Section 2, Section 3 and 11 of the Statutory Instrument Act of 1947 required the very publication of the very draft made under the Enabling or Parent Act of those rules or regulations must be published, and these requirements, if not fulfilled, then such delegated legislation made under the Parent or Enabling Act would be declared as ultra vires, and in the same case in United States of America, before enactment of the Federal Register Act 1935, there was no mandatory provision of postnatal publicity of those draft rules or regulations made under the Enabling or Parent Act. But after the enactment of Federal Register Act 1935, it becomes mandatory to publish all the draft rules made by the executive or administrative authorities as per the requirements of the Federal Register Act 1935. So also the Federal Administrative Procedure Act 1946 also provides the postnatal publication of all those draft rules or delegated legislation made by the executive authorities. And in connection to that, we'll go to the very position of India. So regarding the Indian position, we would like to discuss the very important leading case, Harla versus State of Rajasthan. In 1951, the Supreme Court expressed that the very publication of the draft rule of the subordinate or delegated legislation is regarded as an essential requirement for its validity, and if it is considered essential for the validity of the delegated legislation where the law is silent as to publication, so in the leading case the Enabling or Parent Act was silent as to the publication. The delegated legislation made by the delegate was not published. It was not made known to the general public through any means. The Supreme Court held the delegated legislation invalid on the ground that it was not published. The Supreme Court has made it clear that publication of some reasonable sort is necessary to make the delegated legislation effective. The court has held that it would be against the principle of natural justice to allow the subject of a state to be penalized under the law of which they had no knowledge and of which it is they could not have acquired the knowledge. Even with reasonable diligence, it is the demand of natural justice that therefore a law becomes operative, it must be published. And in the same way, in Narendra Kumar versus Union of India in 1960, Supreme Court expressed that the delegated legislation which was not published as per the requirements of the Enabling or Parent Act, then it would be declared as invalid, as the very requirement was that it must be published in official gazette and so also in a Gujarati newspaper. As it was not followed in the proper way, then it was held as invalid, as it was not published in the official gazettes, also in the Gujarati newspaper. And in the last leading case, which already we have discussed regarding Govind Lal and the Agricultural Market Committee in 1976, the same opinion was expressed by their lordship that if the very publication of the draft rules or the delegated legislation is not compiled by the authorities, then it would be declared as procedural ultra virus.